Hello, this is Matt on the Moon Lambeau channel. A judge in the SEC v. Ripple case today filed a document, brand spanking new document, ordering that the SEC and Ripple take part in a settlement conference, but there's an asterisk. It's if they believe it will be productive. Also, Gary Gensler finally coming out of whatever cave he's been hiding in. And for the first time since the news broke several days ago regarding the horrific defeat almost entirely across the board for the SEC and regarding the SEC v. Ripple case, he finally had some words to say about that. And some are reading his words as an indication that the SEC actually is going to appeal this darn thing, but perhaps that's getting a little bit ahead of ourselves. It's certainly is a possibility. So I want to talk about that. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. The first document that was filed regarding the SEC v. Ripple case is the one that's on your screen right here. If you look towards the bottom right, you can see that it was signed by Judge Analisa Torres, and there's just a little box here that's checked. And so it states here, the above entitled action is referred to the Honorable Sarah Netburn for the following purposes. And the box that's checked right here is general pretrial, including scheduling, discovery, non-dispositive pretrial motions, and settlement. And then separately, there's a box here which just is checked that just says settlement. And of course, settlement, I'm sure most of you are aware at this point, settlement can occur after a major ruling after summary judgment, which is something that I didn't understand since I have a legal background. I pretend to be a lawyer on the YouTubes, you know. But I didn't realize that for much of the last 2.5 years, you can have settlement after a defeat, even if you're a defendant, in the remedies portion of the case. And so the settlement box here being checked, and just, well, don't forget, let's be clear. When it comes to the ruling, it was utter devastation for the SEC, unquestionably. Because the thing that mattered most, and whatever mattered second most, we could argue about, but it wouldn't even be close to mattering as much as the first thing. The thing that matters most is whether or not XRP itself is a security. So, devastating defeat for the SEC. Even so, if you want to speak from a technical perspective, which is fine, it's still technically a split decision. There are certain things that Ripple didn't get going their way, but it's not going to matter in the end. And I've gone through that in detail, so it's not the purpose of talking about it, but I'm just noting this. So that's the reason there could even be potentially a settlement here. But as far as, you know, what this means, there is a boom, one of those boom tweets shared on Twitter. This one is from Jack the Rippler. He wrote, Judge Torres has referred the Ripple case to Magistrate Judge Netburn. Settlement anytime, hashtag XRP the standard. Well, that's not quite what that means, and it means an attorney, Mark Fagel, responded to him and clarified. He said, this is not a boom, however many O's you add. The same order was entered 2 years ago. It's now amended to authorize the magistrate to consider pretrial scheduling and potential settlement. It does not mean there is an actual settlement under discussion. And so, look, I can understand why people, upon seeing this, would think, oh, man, does this mean that there's actual settlement discussions taking place right now? No. It's just a misunderstanding of what the paperwork means, which is pretty reasonable, considering that not myself nor the vast majority of you listening would have any sort of background in this. And so that's why I appreciate the clarity from a former SEC attorney, Fagel. But then there was this. So there is more. So, again, that demand came from Judge Analisa Torres, said, hey, Judge Netburn, go do that, and Judge Netburn did that. So take a look at this. The documents on your screen, I'll make it full screen. It was shared by Fox Business journalist Eleanor Terrett, and she said, new, Judge Sarah Netburn orders both Ripple and the SEC to agree on 3 mutually convenient dates to schedule a settlement conference, quote, if they believe it to be productive at this time, end quote. Also recommends scheduling 6 to 8 weeks beforehand due to the court's busy schedule. And so, yes, this is something that was ordered. If you're looking at the screen, you can see this is so ordered, but there is flexibility here. It doesn't mean that this must happen, which is why she wrote here again regarding to both the SEC and Ripple, they should proceed with this settlement conference, quote, if they believe it would be productive at this time, end quote. And I think a lot of people were missing that upon hearing about this news. You got to read the document. So yes, this is ordered, but there's the if in there. It doesn't mean that this is necessarily going to happen. And I'm still sitting here thinking, if I'm Ripple, I mean, if I'm Ripple, I'm the big winner. Not literally in every point, but okay. Do you even bother appealing with anything? Skeptical of that. Would you go into settlement even right now? I mean, if there's something particularly favorable, it's just, I'm not seeing the point. Why not let the rest of this play out? And so then Charles Gasparino retweeted that from Eleanor Terrett and wrote, wait, if Ripple won, why is the company settling? Well, again, this is a misunderstanding because this doesn't mean that Ripple, the company, is settling. It does not mean that. As I cited, it just means that if the parties think that it would make sense for them and be productive at this time, then you are ordered at that point, if that's true, to set up a settlement conference. And, again, even though Ripple, like I said, had the biggest possible win out of this case, it doesn't mean that there weren't little things, mostly inconsequential things, that Ripple lost on. And even if they have to pay a fee to the tune of like hundreds of millions of dollars, that's still going to be a little thing for them. Money is not an issue. That would be a non-issue. And so just because it's a split decision, it doesn't mean that it would be unreasonable to characterize this as a stunning defeat for the SEC and a massive one for Ripple, because across the board, that is true. And then if you want to get into the nuance of it and say, okay, what little things did Ripple not get, which they'd hoped would have gone the right, okay, we can do that. But let's be real here. It was a massive defeat for the SEC. Big win for XRP holders as a result as well. And then Eleanor Terrett clarified further, in line with what I've been saying here. She says, to be clear, Judge Netburn is suggesting that both sides agree on some possible dates for a settlement meeting if they believe it to be productive at this time. This doesn't mean we'll see a settlement in 6 to 8 weeks. It means that if they do decide on a date, it will have to be scheduled 6 to 8 weeks in advance of the desired date due to the court's busy schedule. Yep, that's it. And then we had Gary Gensler, that's right, Kim Jong Gensler, saying some stuff finally regarding the SEC v. Ripple case. And I actually went ahead and transcribed what he said for you. And I'll tell you, the video clip of him here, Eleanor Terrett shared it. The clip's 32 seconds, and there were so many ums and ahs. I took them out, but it's like I'm looking at this as transcribed right here, and it's just like a few lines. I mean, you could consider it a couple sentences effectively, and it took him 32 seconds to spit this thing out. This guy, I'm telling you, like he does not quite know how to handle this, which is probably why he's been hiding on this, since the ruling came down several days ago. But anyway, so here you have it from Eleanor Terrett just several hours ago. Breaking: Gary Gensler addresses the Ripple summary judgment decision for the first time since last week's ruling. And here's the quote. Let's see how long this takes me to read this. It's not going to be 32 seconds. We are pleased from that decision, recognizing the importance of protecting investors, the institutional investors, and that the court movement with regard to fair notice. And while disappointed on what they said about retail investors, we're still looking at it and assessing that opinion. So there you go. Well, how long did that take me? About 16 seconds? So half of his 32 seconds was that was half. And mind you, I wasn't trying to read it fast. I was just reading at my normal pace. It took me 16 seconds. I wasn't speed reading or anything of the sort. 16 seconds. Took him 32 seconds to say it. He's just, oh, poor little Kim Jong Gensler, poor little Kimmy. Oh, what a good time. It's a fantastic time to be alive. So, you can take what he said there as an indication that this isn't over, but that's because it literally isn't over. Maybe just take it as that. And some attorneys within our community think that there will be appeals, some think that there won't be. We'll see. I'm actually going to talk even more about that in an upcoming video, because there's stuff from attorney Jeremy Hogan that I'm going to want to get to here. But then there was also this from attorney John Deaton. He said, we are at almost 2,900 Coinbase customers who have joined to serve as potential amici. So let's pause to note, as a friendly reminder, in case you hadn't heard. John Deaton, he's doing the same thing that he did in the SEC v. Ripple case. And so you can choose to have him representing the case, and he's going to seek to be a friend of the court again, which is what the amici status is all about here. Because it's obvious in the SEC v. Ripple case, nothing against Ripple, but they had their interests in mind, and as they should, but not the broader interests of XRP holders. That's where John Deaton came in. And so he's trying to do the same thing here with the Coinbase case again. And then he tagged Eleanor Terrett and said, Eleanor Turret announced today that Gary Gensler said he was disappointed about what the judge ruled related to retail investors in the XRP case. Remember, Gensler's SEC objected to XRP holders serving as amicus curiae. If you don't want Gensler and the SEC lawyers speaking on your behalf, consider joining. And then after that, just a little bit later, he tweeted out, and just like that, we are at 3,135. People are tired of the SEC's type of protection. So that's amazing. That was in short order. If you got another 235 in, what was the time span here? So we posted that at 1:40. Okay, yeah. So less than 2 hours later, another 235 people signed up. That's awesome. That is absolutely fantastic. So it's the same deal as, like I said, with the SEC v. Ripple case. If you don't want Coinbase speaking on your behalf or the SEC speaking on your behalf, if you want to, you can choose to jump in. I think it's fantastic what John Deaton is doing. And he's not, this is all out of his own pocket. He's not getting money to do this. He's just doing it. It's financially a negative for him, but he's got the fire in his belly, and you got to love him for that. Absolutely. Highly impactful in the SEC v. Ripple case. I'm hoping for a similar type of impact in the Coinbase case. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.